Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and this is another episode in our series entitled, You Mean I Actually Have to Read the Title Commitment? And in this episode, where I am once again joined by my friend Jake Mensinger. Jake, would you introduce yourself, please?
Sure. Jake Mensinger, First American Title, Clark County, title officer here, and been doing this for a while and looking forward to talking to you a bit today.
Thanks for being here. So in this episode, we want to talk about a scenario where property is listed for sale in the fairly recent aftermath of a death. And so let's create an example. I'm the listing broker and I go and meet with Paul. And Paul says, I'm selling my parents' home, my mom and dad, Jane and John Doe. My mom died. Jane died 6 years ago. My dad has lived here by himself for the last 6 years, but he passed a month ago. And so I'm selling the property. And so I'm the listing broker, and Paul says, I have authority to sell the property. And so I have a listing agreement signed by Paul. Now I pull the preliminary commitment for title, and it shows Jane and John Doe as the fee simple holders of title. I know enough from having watched this video series to say, ooh, I got to call Jake and ask him what this means. So Jake, what does this mean?
Sure, absolutely. A lot of times when you're dealing maybe with a husband and wife and one of them passes, they may do nothing with the property. And so I might not know about that. So like you said, maybe 6 years goes down and then the other spouse passes and then you're dealing with their child and meeting with them at a listing. And so your title report comes out, husband and wife, and I got to put my detective hat on and figure out, okay, why am I dealing with the son? And so a lot of times I'll pull an obituary. I'll look for an obituary. What does the obituary tell me? If there's no death certificate recorded, or there's nothing in the auditor's records for a probate or anything to tell me that someone in title has passed, then that's kind of where I start. And so I'm going to need to know, is there an open probate for our deceased party? If so, where? Because they might have opened it somewhere else in Washington, and I'm only searching in the county where my property is. If they opened it in another state, that might not have jurisdiction over our property here. So that's kind of where we're starting is figuring out when did our people pass, and I'm going to start asking some preliminary questions that probably only that son is going to be able to answer for me, or at least get me in that direction. But I need to know who we're dealing with, who those heirs are of those people. And if there's not a probate telling me a court appointing, then what we have is a lack of probate. And so I asked some questions of who the heirs are, and was there estate taxes, maybe creditors, those kind of things. I need to get myself a little familiar with maybe the estate.
Okay, so backing up one step, brokers, let's make sure that you understand kind of the playing field that we're on. In our scenario, title is in the name of Jane and John Doe, who are now both deceased. Well, you already know that in order to convey title, somebody has to sign a deed. That happens in every transaction. Seller signs a deed conveying title to the buyer. Well, title is in the name of Jane and John Doe, and they're both deceased, which means that they necessarily can no longer sign a deed. There is no way using a deed to convey title from the current holders of title. Well, that just means then that Washington law has found another way to convey title from these people who are no longer capable, because they're deceased, of signing a deed. And so generations ago, Washington law created the probate system, which would say that when the two people are deceased, their estate should be probated, and then the probate court will do the process within the court system of converting title from Jane and John Doe to whoever is going to take title. And now that person who's taken title is a person who's alive or an entity that is functioning and can convey title to a future owner. Simple. But that would require you go through a probate in order to do that. So, Jake, you said something about lack of probate. What are you talking about?
Sure. As a title company, I'm going to want to see someone do a probate. That's a little easier for me. It says that the court has appointed someone to act for this estate. Usually that's a personal representative or an executor. So that's very clear for me. But if there is no probate, then I got to figure out who the heirs are to determine who's going to sign my documents.
Okay, so let's back up a second. We've got Jane and John,
Yep.
both on title.
Mm-hmm.
Jane died, let's say Jane died in Colorado 6 years before.
Sure.
Okay?
Yep.
And now John just passed in Washington last month. They're both on title to this property.
I kind of need to connect dots, right? So I'm going to need a death certificate for Jane. I'm going to need to know where Jane's interest went when she passed. So did Jane have a will? Did she probate someplace else? So I can determine Washington's a community property state. So if they say, hey, Jane's interest went to John, then we can kind of move forward to John and we can move past Jane's interest that way. Typically, I'm still going to want to record a death certificate, so then that's of notice for everyone looking at the chain of title to see, okay, this is why we're not dealing with Jane anymore, is because Jane has passed.
Okay.
So then that moves us to John, right? And so then who's John's heirs? So if John's not married, then Washington's succession law would kind of take that down into order. So then it would be children of John, right? And so who are John's children? Well, maybe he's got 7 children, maybe he's got 1 child, maybe he's got no children. But those are kind of the things what we're kind of finding out. This lack of probate affidavit is asking those questions. Asking, has the estate received assistance from the state? How much is the estate valued at? Maybe there's an estate tax that could be owing if we're over $2 million that this person has accumulated and everything. So those are some of the things I'm looking for to determine who's signing and what other concerns I may have. But a lot of this, we're taking people's word for it. So I'm sitting here and you're telling me I'm the only child, right? And so that's why I may pull an obituary and say, wait a second, this obituary says that John had 3 children. Oh yeah, but he disowned them a couple years ago. I don't get involved in that. So the 3 children all would need to sign for me. Unless they wanted to go to a probate and then they can have one person appointed, that's fine. But all 3 of those would need to sign. I had one of those yesterday where I had to tell somebody that. Just one person had signed and he thought the will said he was the executor, so he thought he could sign, and this was the son. And it's like, that's fine, but until you go and probate that will, that doesn't give you the authority for me to sign, just you.
This is a hard message to deliver. So Paul has come to you and said, I'm the heir. This is my property to sell. And you do this background work or you order the preliminary commitment and you're working with Jake who does this background work and Jake says, well, wait a minute, Paul has 2 brothers. And then Paul says to you, yeah, but my parents disowned them. They're out of the picture. Don't worry about them. I'm going to be the one who's signing. Well, brokers, it's not going to be an easy message to deliver to Paul that's not the way it's actually going to work. He either has to probate, which is going to be an intimidating process to some people. It doesn't have to be an intimidating process. It doesn't even have to be a super expensive and time-consuming process. There is that myth that it will be, and in many cases that myth is deserved. But there are certainly scenarios where a competent estate lawyer, probate lawyer, can help somebody get through a probating process if it is a simple estate without great expense and great loss of time. That's a different issue, but just make sure that if probate is what's required, it doesn't necessarily mean the end of the world. But let's say that Paul has said, I don't want to probate this, and I don't talk to my brothers. Well, delivering the message to Paul that he's going to have to choose between those 2 options, neither of which he wants, it's not going to be an easy message to deliver. Blame Jake. Blame your title officer. You can deliver the message and point back to Jake, or you can simply send the seller to Jake, to the title officer, to say, would you tell them exactly what you need? And then let your title officer be the bad guy. Don't put yourself in that position of having to be the bad guy. Fair enough?
Yeah, absolutely. Because you might not ask for everything I need, right? Or maybe word it differently. And so, yeah, have them call me. I'm happy to explain it to them. And most title people would be, because you're going to come to us and you need our help to resolve it, or at least be able to say, if you want me to insure it, this is what I'm going to need. Now, each title company may be different, right? So you may be dealing with a different underwriter that says, you know what, I feel comfortable about this. Or you may be dealing with me that says, I'm nervous about this. So there is that. And so a lot of times if I tell somebody no, I might tell them, I may say no, maybe call brand X over there, and they might have a different solution for you. So there is that as well.
Okay, great. So again, brokers, you're not in the business of solving the title issue, but you have to recognize the title issue. And you also have to understand the value of your resources and lean into those resources. For a question like this, you have no more valuable resource than your title officer.
Some of these are not cut and dry. And so I may have more questions. Like I had one, I think there was like 7 heirs. One of the heirs was a minor.
Oof.
So they could not sign. And so we had to tell them, you have to go probate. So there may be a situation where I say, I am just not able to insure this unless you probate. But like you say, that might not be so hard. A lot of times I'll see a will, and if the will is very clear, you could get that personal representative appointed somewhat quickly, right? And then that's what we want to see, is that's the person who can sign for our transaction.
So what Jake just said is the seller may not have to complete the probate in order to be able to convey title. There are ways that the deceased person could have created their will to give their personal representative, once the PR is appointed by the court, to be able to sign the deed to convey the property even before the probate is completed. But here's something I want brokers to understand. Brokers, it's possible that when a property has to be probated, you're not going to get through the steps that are necessary to empower an individual to sign the deed, or known individuals to sign the deed, before you'll get to the closing date. If you list the property up front, I really butchered this explanation. If you list the property and then you find out, because you've properly pulled the preliminary commitment, that you have a title problem because of a deceased person, you may want to put a pause on that listing. And I know that's not what anybody ever wants to hear. When you've got a listing, you want to go sell it. But if clearing title, getting insurable title, does in fact require a probate process, you may not have a person with signing authority before you get to the closing date if you don't pause that listing in order to solve this problem first. Is that a true statement?
Yeah. You could be stuck and we're sitting here waiting for a probate, or I may say, like, I need more, right? And so, yeah.
So get those issues cleared. Let the seller know we need to just hold on this listing until we can get some of these issues resolved. Jake, jumping subjects a little bit, same topic. What is a transfer on death deed? What is that?
Sure. So what you're doing is basically, if you're entitled, you're going to record a deed tomorrow that says, upon my passing, I would like my property to go to Jake, let's say. And so then once you pass, then what you would do, or I would do, was then take your deed, take a certified death certificate and go record that with the county. And that essentially would put the title in my name, right? And so you think, great, but as a title company, I still have questions. So those transfer on death deeds could be revoked, and I don't know about it. Maybe you revoked it at the end, I don't know. So I have an affidavit where I ask some questions, and I ask a lot of the same questions I may ask for like my lack of probate affidavit.
So hold on one second.
Oh, sure.
Because the transfer on death deed really is a lack of probate process, right?
Yeah, essentially, yeah.
So we talked a second ago about when a person's deceased, they no longer can sign the deed. So Washington law generations ago created the probate process. The transfer on death deed is a new process in the big scheme of things. Transfer on death deeds have been around for probably, 5, 6, 7 years at this point. But in the big scheme of things, that's a fairly new process. And so people, whether it's, estate planning lawyers, individuals and even title companies, they're still trying to figure out how to work within the structure of the transfer on death deed process, right?
Correct.
Okay, so now go back to what you were, I just want to make sure people understood that the transfer on death deed is another way of avoiding a probate.
It is,
But
yes.
but it required action by the deceased person prior to death.
Prior to death, yes.
Okay, so now go back, if you would, and I just want to make sure people understood that this was a process that avoided probate. That's why you have a title issue.
Gotcha. So yeah, so you could use this as your kind of solution to not do the probate. And so a lot of times those are kind of becoming more frequent in my mind. I've seen more of those, and now I'm actually, like you said, it's fairly new. So now I'm actually seeing people then trying to transfer. The person's died, now we're seeing those transfers out. And so in those particular cases, we do ask for a lot of the same questions, like who, because that's a deed, right? It's given to someone. But again, it could be revoked. They could receive assistance from the state. There could be creditors out there that I could be concerned about.
Why? Why are you worried about funds from the state? Why are you worried about creditors?
The state could lien the property. So that could then be on me. So like, how familiar is this person that got the property really with the person that passed away? I've seen a couple recently where they've done a transfer on death deed to their neighbor. And I thought, neighbor, okay, well, maybe the neighbor was taking care of them. We don't know their situation. So that's kind of where we ask some more questions. It becomes more risky for us as the title companies. So you may see different title companies asking for different things on those. So definitely better to, if you see that transfer on death deed, we will put an exception on our title report. You will see your party and title that you're dealing with, but then throughout the title report will be an exception that says your party received title via a transfer on death deed. And then I'm going to have a couple other exceptions that kind of talk about like some of the things that I'm concerned about. The state, attacks, assistance from the state, those sort of things.
And the reason all of that comes into play is because if the parties went through the probate proceeding, one of the things that the probate court does is take into account whether or not the deceased person had creditors who are entitled to funds from the proceeds of the estate, right?
Correct.
And when we avoid the probate process, nobody's done that creditor claim check. And so for as long as those creditor claims could survive after the death of the person, your title company would be at risk if those creditors ultimately asserted claim against title to that property that's now been transferred to a buyer, right?
Correct.
That's why you care.
Mm-hmm. Absolutely. And so you're going to see some of those, like right now, we kind of talked a little bit about this. We like to see a couple years go by. Like we don't want to see that transfer on death deed. The person died last month, and then that person's trying to sell it tomorrow, right? So that the more time that goes by, the more I feel comfortable that no one's coming out of the woodworks. Within that first 2 years, I might not be able to feel good enough about this, so I'm going to have exceptions on my title report that maybe your lender's not going to approve of if you've got a buyer working with a lender. So again, just another reason to, if you see that on there, let's jump on it and figure out what needs to happen.
Comes down to the listing broker ordering that preliminary commitment early, reading it, understanding that there's an issue. Anytime you've got one person signing and the title to the property is held, even if they explain, it's my parents, it's my mom, it's my great aunt, I'm the heir, I'm going to inherit the property, whatever that explanation may be, anytime there is a disparity between the person who's holding themselves out as the seller signing the listing agreement and the name or names as fee simple holder, stop what you're doing, pick up the phone, call your title officer or call your escrow officer, because you have a problem that has to be solved. Solution might be simple, the solution might be complex, but you have a problem and it has to be solved before you proceed. Buyer brokers, when you're representing a buyer, purchasing property, and the seller has signed the purchase and sale agreement, and you see a difference between the name of the person who signed the purchase and sale agreement and the fee simple holder of title represented on the preliminary commitment, your buyer has a problem. So ask your escrow officer and title officer their opinion of that problem before your buyer gets any further into this transaction. Anything else on this topic?
I don't think so. Some of those, again, I just would reiterate that each underwriter, each title company may view things a little bit differently if you're not going through a probate and you're trying to do a lack of probate, or you're going through a transfer on death deed. So it's imperative that you work with the title company ahead of time to make sure you get what you need and there's no hiccups that way.
Yeah. No, there is no one size fits all answer to that scenario.
There is. And I may say one day, I say, well, I kind of like this. And then you come back. I look at it as we're working together through this. And so I may ask more questions. And the more questions I ask, if you answer them correctly or you answer them the way I like, then I get more comfortable and then it becomes easier for us. So,
sounds great.
Yeah.
If you have questions on this topic or any other, please visit warealtor.org and follow the links to the Legal Hotline to ask me a question. Thank you for being a Washington Realtors member.